First of all, I would like to thank the Honorable Member from Nongkremba Aden Milabusamoy for raising this special motion to deliberate about his point on this floor of the House. I'm very thankful to the other Honorable Member, Rupa Marat, MLA from Dadengre, Dr. Mukul Sangma, MLA from Songsak, the Honorable Member from Molaiba, Bresterwell, Marbanyang, for bringing a point to highlight another fact about the land system in the state. When I listened to the discussion, to the point raised by the Honorable Member, that yes, land is a very tricky issue, and the issue of governing the land in the state also, it is a very tricky issue, as elaborated by the Honorable Member, where the clan, the right, the HIMA, the Risk Council, and the private member have a different role in governing of the land and the Risk Council. And it is not very easy for any particular thing to encroach upon the right of the people. But I'm very thankful that till today, there is no forceful encroachment, alienation. All the transfer of land is subjected to the rule of law. So, we know that different Risk Council, they have a different land management system. The Garo Hills, they have the Garo Hills Autonomous Risk Council Land and Revenue Regulation 1954. The Giant Hills, also they have the Khasi Hills, they have just passed a new act, the Khasi Hills Autonomous Risk Council Regulation and Administration of Land Act 2021, and the Giant Hills have passed the Giant Hills Autonomous Risk Council Management and Control over Land and Assessment and Collection of Revenue, Third Amendment Regulation 1985, and so on and so forth. All these acts are meant to streamline the land holding system of the state. The state government in itself is administering only the revenue land, the government land, and also the transfer of land between the tribal and non-tribal. So, having said that, as we know that Meghalaya was established as a state on the 21st, as the 21st state of India by the Northeastern Areas Recognition Act 1971. The new state of Meghalaya was established on 21st January 1972, comprised United Khasi Hills, Giant Hills District, and Garo Hills District. Under the restriction of the Constitution, overall management of land vested within Autonomous Risk Council, but the power of the state under the Constitution also exists side by side. However, statutory responsibilities still remain with the government in the Revenue and Disaster Management Department, as also Superintendence of Administration of Government Land. So the Assam Land and Revenue Regulation 1886 was adopted in 1972. The ALRR was adopted by Meghalaya as applicable to all the government land in the state. Certain provisions of the Act are applicable more or less throughout the state, subject to some exception or modification with respect to restriction of land in Autonomous District Council. So, government in various departments has a large area of land spread all over the state. These lands are occupied by various government departments and are administered by the concerned department under the general supervision and control of GAD and Revenue. So the government in various departments have a large area of land spread all over the state. These land are occupied by various unrevenue department. So for this land, there is a procedure how to be allocated, and there is also a procedure how to keep to different departments. So the Meghalaya Land Survey and Record Preparation Act 1980 provides for the cadastral survey of land in the state and preparation of land record. The act was amended in 1991 to involve this council in implementation of provision of the act, as the scheme of cadastral survey has been decided to be implemented by this council with the financial and technical assistance from the state government. So, as you rightly know that most of the land is in administration of this council. So the government from time to time tried to have a conversation, discussion with this council to adopt the cadastral survey. Because as rightly mentioned by the honorable member from Nongkrem, that there is issue of the occupation of land, or there are some landholding who hold a very large tract of land. There are some who didn't have a portion of land. But this is outside the issue of the government, sir, because as I said, that there is a rule which governs the HIMA, there is a rule which governs the HIMA land, there is a rule which governs the community land, there is a rule which governs the council land, and so on and so forth. So that's why I tell that land holding system in Meghalaya is a very, very tricky issue. I really like the statement by the honorable member LO that more exhaustive discussion is needed if we want to see that the land holding system in the state of Meghalaya to have semblance of uniformity all over the state. But it is easier said than done, sir. So, most of the land, when it is registered with the due process of law, as I said before, sir. No land is being acquired without the NOC from the headman or the NOC from the Doloy or the NOCMA, as the case may be. The PATA is issued by GHDC. When we talk with GHDC, it's only on the basis of NOC issued by the NOCMA concerned. So the process of law for registration of land is followed by this council as per their rules. So in the matter related to the raised by the honorable for acquisition of land for highway, honorable from Songsak. So land acquisition under the is followed under the NHAI Act 1956. The Commissioner of Division notified as arbitrators after approval of the government of India. The people go to the arbitrator if not satisfied with the award of the land acquisition of the competent authority. But as I said before, sir, whatever we do, it is up according to provision of the law. The honorable from Maulai has raised the question of the public hearing in Daistong. So the public hearing is done as per rule, and it is the DC has submitted the report that everything is done as permitted by the law, sir. So I may bring to the information of the House that most of the land in the state of Meghalaya is not registered, sir. It is very difficult for the government or for the people in place to identify which. But having said that, so as I mentioned earlier, that necessary exhaustive discussion is needed to see that some uniformity all over the state could be done. So when we talk about the issue of the So the honourable member from Nongkrem talked about the Chapter 10 of ALLR 1986. So this act was intended to regulate registration of documents in the land in certain areas, especially tribal and backward tract. It was meant to prevent exploitation. It is applicable in some part of Meghalaya as notified. So, sir, we have seen that the government from time to time also, as mentioned by the honourable member, that it is trying to create the land bank. Yes, that it is for the need of the government as a whole and the community. But having said that, all the procedure have been followed in anything which the government is doing. So, sir, as I said, sir, earlier, that all this council, because most of the issue which have been raised is related to the relation between the registration of land in the Karo Hills Autonomous Council, relation to the Nokma, Aking land, and that Mosa land. As I said, that different council, they have a different role and act. So all the registration is done as per the rules and the act. And I will come back to the revenue department, sir. As I said before, that the revenue is dealing only with the government land and allocation of land, of the government land, which is done as per the process of the law. And also, the department is dealing with the transfer of land between the tribal and the non-tribal. And this also is done only after they fulfilling all the necessary provision of the law. Another thing which I want the honourable member raised about the from Malay raised about the petrol pump in Jorabat. So the lease agreement is executed between the MMDC and the tribal persons, sir. It is not a case of alienation of land. But having said that, as I said before, that this question is the need of the hour. How to streamline the landholding system, how to streamline the land transfer system, and how to synergize between the Benami Act, the Land Transfer Act, and other regulation, so that more stringent law could be made to prevent, if any, alienation of land which is illegal. We from the government will try to implement. All the rules as per provision of the law. So if there is anything, the government will not sit tight. Will try to see that all the illegal, whether Benami or illegal holding, if it is there, we will try to see to act according to the provision of the law. With these few words, thank you, Mr. Deputy Chairman, sir.